Welcome to That's What She Pled, with attorneys Christina Goldberg and Julie Luhrsen from Luhrsen Goldberg LLC, law powered by women. It's time to shake up the old standards of law and of business. Join these two witty, intelligent, and sassy female business owners who are taking their industry by storm, challenging stereotypes and shattering ceilings. These two are on a mission to educate, empower, and support not only their own clients, but other powerhouse female entrepreneurs. Come for a laugh and stay for the vibe as Julie and Christina hold nothing back and share the truth of what it is to be female attorneys and business owners through discussion of current events, original stories, and inspiring guests. Now, on to the show.
Florida is a place to be. The social scene, cultural scene, food scene, and crime scene. Your podcast hosts, Julie Luhrsen and Christy Goldberg, are the founders of the firm Law Powered by Women. Located in Lakewood Ranch, they focus on personal injury cases. I'm Patrice Sikora. Christy, Julie, what is the most common type of case you see?
Probably for us, the cases that we bring into the firm are going to be auto accident cases. I know everybody talks about the crazy drivers in Florida, which, excuse me, I take issue with just because everybody in Florida is not from Florida. So it's actually not Florida drivers, it's everybody else. Me being a native Floridian, I have
a little bias here.
It's fine. Everything's fine. But yeah, for us, it's auto accidents. And it's a huge business in Florida.
I remember being down there and seeing billboards along the highways, just every billboard, personal injury lawyer, bring your auto accident here.
Oh yeah,
that's true.
Yeah. Yeah. It's a big business. And it's so funny because it can turn into, listen, there are certain parts of Florida that are much more known for instance, fraudulent claims, or, the legislature is always trying to change the auto laws, the auto insurance laws to help abate some of the insurance, the fraudulent insurance claims. But it has turned into such an environment where now suddenly you've got people thinking, oh, okay, I was injured in an accident, or I was in an accident. I didn't actually suffer any losses. My car was kind of damaged a little bit, but that can be fixed. And I didn't miss any work, but I still want to be a millionaire.
So what makes a case a case?
They're based on somebody being careless behind the wheel, because everybody has a duty when you're out there driving to pay attention to what's going on and to drive with some care. And if it's pouring down rain, you probably need to adjust your speed. If the roads are crowded, again, pay attention. And so when an accident happens because somebody really wasn't doing what they should have been doing and keeping an eye out, then if injuries result to somebody that are as a result of the crash, there's responsibility out there owed by the at-fault driver to the injured party. Christy, do you want to parse it out a little bit different, a little bit more specifically?
Yeah, probably more specifically. So you're talking very generically. Any book on the subject is going to tell you that negligence is comprised of duty, breach, causation, and damage.
Yes.
So we all have a duty to drive safely. All right. So we can agree on that. Breaching that duty, that is the liability aspect. Okay. So if it is a rear end accident, for instance, in Florida, if you rear end somebody, you are immediately presumed, it is a rebuttable presumption, but you are immediately presumed to be at fault for the crash. You should have been paying attention, been able to stop your vehicle. But the breach can come into question. The liability of it can come into question when you've got a he said, she said, oh, I had a green light. No, I had a green light. Or you have a T-bone, or you have all sorts of various, he cut me off and then slammed on his brakes and it was nothing I could do, all of that. But typically liability doesn't become a huge issue. Generally speaking, you've got a defendant who did something stupid and who says, okay, mea culpa, I did it. So there's duty, there's breach. Causation, that means, okay, your guy had a duty not to hit you and he hit you. Now your claim that you've been injured as a result of this crash is up for debate by the insurance company that you're going after. The insurance company is going to do everything in its power to say, no, you were already injured, or no, there's no way that impact could have created the level of damage that you are claiming as a result of this. And so causation is 9 out of 10 times, that's where your battle comes in: pre-suit, during litigation, during trial. you are really battling causation and you are bringing in the medical experts to say, yes, this actually is possible from a car accident that caused, $300 worth of damage to a bumper. It actually is possible that now the driver needs surgery. Of course, these experts are, bought and paid for by each side, and it's now the battle of the dueling experts, but this is causation. Damages are broken out into before resolution or verdict and then post. And so the damages aspect are it's very interesting because look, if you suffer losses as a result of a crash, typically you're entitled to those losses, those past losses that you've suffered. So if you've paid any medical expenses out of pocket, you're entitled to that. If you've lost any wages, you're entitled to that. The future losses and the pain and suffering, those only get triggered at a certain point. Those only get triggered when you have doctors treating you in a certain manner and making certain claims on your file. And that is where there seems to be a lot of confusion just in the general public, because you've got the commercials and you've got the billboards and you've got these, oh, if you've been injured, you may be entitled to. Well, I may be entitled to $18 billion because of whatever, but that doesn't mean I get it. So, you've got to be, the fact of the matter is that despite what everybody thinks, if you're in a car accident, in order to collect and in order to get your future damages and to get any level of pain and suffering, you actually have to have a valid injury. You actually have to be damaged to the extent that not just a bought and paid for expert is going to say that about you. So like any other law firm, and when we get people walking in the door who want to make a claim and sit down with us, and as Julie and I start asking questions, it becomes more and more clear that this is a person who is sitting in our office because they've seen a commercial, not ours. They've seen a commercial or they've seen a billboard that tells them, hey, you could get all of this money. You're not a valid claimant. I'm not interested in handling those files. That's not what our firm does. It's not what we're here to do. But in a pretty large nutshell, I think that's basically what makes a valid claim is the duty, breach, causation, damage. We've got to be able to hit each one of those on the head.
What? Go ahead.
I'm sorry. I just wanted to chime in to say every state has their own requirements as to what kind of insurance coverage drivers need to carry. In Florida, what's surprising to many is that liability coverage, that is coverage to pay for pain and suffering, past losses, future losses, and that sort of thing, is generally not required of most drivers. Few exceptions, if I go out there and I commit a DUI, yeah, I'm going to be required to carry some liability coverage, but that's not mandatory. We have very minimal mandatory insurance requirements in this state. And so another situation that is not that uncommon is someone was in an accident. There's no question about liability. There's actually not much to debate about their injuries and the resulting damages. The problem, the at-fault driver didn't carry liability coverage. The injured party didn't carry the backup sort of version of that called uninsured motorist coverage, which protects you if you're in an accident with somebody who doesn't have insurance. And so it's basically very unfair.
Mm-hmm.
And, people get frustrated with us, which, we're the messenger. So it's unfair, but I certainly understand it when we tell them that I'm sorry, I really can't do anything for you in most circumstances.
Mm-hmm.
So
it is, however, the job of an attorney to make sure they're barking up that tree.
Yes.
Because there's certain, if the driver was on the job at the time, then there's different insurance policies to look at, or you never know what the circumstance is. And so that's our job, the due diligence aspect of it, to make sure that we've looked at every
run the rabbits down the holes.
Exactly. Every possible avenue of collecting, because we don't care where we collect from, right? We just want to get it for our client. But yeah, a lot of times, and being the person to have to tell a client, hey, there's nothing we can do. I mean, they get very angry, and I understand this has altered their lives, and a little bit of pushback. Well, yeah, but why can't we just sue the person? Because when you make a claim, you're making it against the insurance company, right? So, well, why can't we just sue the driver or the owner of the car? Well, we could, but on a very basic level, if the driver or the owner of the vehicle doesn't carry liability insurance, the likelihood is that they don't have any assets to protect, because that's why you carry it, to protect your own assets. So we need to look at that. And secondarily, you can't access their homestead. You can't. So unless this person is independently wealthy, has, multiple vacation homes and property ownership and all sorts of readily accessible assets, yeah, you can sue them. You can go get a piece of paper that says that they owe you money, but good luck. And that's typically not your best move.
Why is liability not required?
The legislature
Yeah.
made that policy decision a long time ago. They mandate what's something called no fault or PIP insurance, which provides everybody with a basic level of coverage to help pay for medical care. But it's really at levels higher than Christy and me, that, in other words, the state legislature.
Mhm.
They've tried. They are trying. It's likely to change in the not too distant future. But for now, this is the landscape that, we work on.
Yeah.
Hmm.
Yeah. The legislature decided that it would be, for whatever reason, more beneficial to make sure that anybody who was driving on the road had their own insurance, so that if whether you're at fault or not, you still treat through your own no fault insurance.
Mhm.
And that's kind of how it goes, which causes a lot of confusion to people. You know, we'll
Mhm.
have people come in and go, well, it doesn't matter who's at fault. Well, it does matter who's at fault, but for that particular bucket of insurance coverage, it does not. But that's the legislature. I think in the next week, one passed actually this past legislative session, but was vetoed by the governor. So it'll happen, just not currently.
All right. Well, then let's keep the automotive theme here, but with a cup of coffee in our hand. Talk to me about that.
Okay. Well, sure. No wonder trial lawyers are largely despised.
No kidding. No kidding. I mean, one of the things that we're always defending is, well, I'm not that kind of person. Somebody comes in here and I'm not litigious and I don't do this, and I'm not in this for the money. And listen, that's been created by the media, a good story that they can latch onto and sink their teeth into. I mean, that's great. I understand it. And there's a place for that and a time for that. Anytime I've given any sort of a presentation on this particular subject, it's amazing because I can ask the audience in front of me, hey, name a frivolous lawsuit. And every single time, without question, what is yelled out is McDonald's coffee case.
Mm-hmm.
Because people don't know, because they do not know, because they were not presented with the actual facts of the case. And it really is fascinating. So this is all the way back in 1992 that this happened. And to this day, this claim actually appears on like Time Magazine's website as the #1 frivolous lawsuit. And it's ridiculous because it is not. But I mean, everybody knows the general facts. So we have Stella Liebeck. This was Albuquerque, New Mexico. She was a passenger in a vehicle. She wasn't even driving. She was a passenger in a vehicle being driven by her grandson. They went through the drive-through, ordered coffee. Her grandson did pull the car over. Stella put the coffee cup between her legs to peel the lid off, so that she could put sugar and creamer in. And when she did that, the coffee spilled.
Mm-hmm.
The question and the information that people don't know is, well, okay, yeah, of course, coffee's hot. She spilled on herself. She shouldn't have done that. Well, it sounds to me like a lot of precautions were taken there. He pulled over. The vehicle wasn't even moving. She was being careful. The biggest problem with it is that, and the photos of this are graphic, they're horrific. But the issue is that she was actually hospitalized for 8 days. She underwent skin grafting, debridement treatments. She was permanently disfigured, totally disabled for more than 2 years. The issue with this was, why on earth would coffee be able to cause that level of damage? And as the case unfolded, we had, the McDonald's quality assurance manager testifying that there was an enforced policy that all coffee be served at 185 degrees plus or minus 5 degrees.
When skin comes in contact with liquid that hot, causes immediately very serious burns.
Exactly. There was an expert who testified at trial that said at 190 degrees, it takes 2 to 3 seconds to a 3rd degree burn, 2 to 3 seconds to have a 3rd degree burn with coffee that hot. And, McDonald's had 700 hot coffee claims before this one, but this is the one, because of the gigantic verdict, that made it to the news and it got everybody in a huff, and it got, gosh, if you can't even be held responsible for your own coffee. Well, listen, McDonald's knew what it was doing. It was keeping it hot so that it wouldn't have to sell refills.
And oh, by the way, Stella and her attorney made a settlement offer to McDonald's for essentially her medical bills. Less than 6 figures. I don't know what the specific number is, but nothing, particularly unreasonable. And McDonald's just basically, again, gave her the big fat finger, and they pursued it. And then in the course of the actual lawsuit, they were able to discover all this information, internal information to McDonald's that revealed that, yes, this was a policy that they keep their coffee extremely hot. They apparently had, reasons why that saved them, I guess, on their coffee bill or something along those lines. But in addition to that, that this was not the first time that they had been made aware, and, that it was against sort of the standards of the industry and all that sort of thing. And so ultimately what happened was the jury, awarded her for her own damages, and then they punished McDonald's through a big verdict. But even beyond that, post verdict, the actual amount of money that got paid was something much, much less.
Oh yeah. The money awarded. And if you look at it in a framework of actually what it means to McDonald's, how it actually impacted them. So the jury award was $200,000. She, however, was found 20% at fault. So the jury award was reduced to $160,000. That's nothing, right? But the uproar was over the $2.7 million in punitive damages. But what's interesting, coffee sales, $2.7 million in punitive damages equated to 2 days of McDonald's coffee sales.
Oh my.
2 days is $2.7 million. And then that award of $2.7 million in punitive damages was reduced to $480,000 post-trial. $480,000. So she got a total of what, $586.40?
And I'm sure that didn't even cover her medical bills then.
No, it wouldn't have. Who's been hospitalized for 8 days?
Yeah.
And the skin grafting and the pain. Oh.
The other, I think, interesting observation that comes out of this whole scenario is just how news gets condensed and condensed and condensed and condensed. So perhaps the local Albuquerque, New Mexico newspaper ran a very thorough story, but then the AP picks it up and condenses it down to this. And then the nightly news jumps on it and they have 30 seconds. And so you can't begin to do justice to the facts. And then sort of the tort reformers and the anti-trial lawyer groups that are out there recognize that, hey, we can do something with this, because, the public response was, this is just crazy. This is greedy trial lawyers and that sort of thing. There's actually a very interesting documentary that HBO has. I think it's just called Hot Coffee. So if you're interested in learning more, there's more out there than what Christy and I presented.
It's fascinating. I mean, there's a Seinfeld episode, right? Where is it Kramer?
Culture.
I think he spilled coffee on himself, and Elaine, literally what she says is, you're suing a company because their coffee's too hot. It's supposed to be hot. Well, that it made it all the way to Seinfeld. So, that's a big deal. And that's a big misconception. And I think that's largely why we face a lot of people who've been really, really injured, really damaged, really suffering losses, and being worried about what people are going to think about them pursuing appropriate action. And it's sad, but yeah, we have to spend an awful lot of time telling people, hey, no, you're not that kind of person. And we're not those kinds of lawyers. That's not what this is. Yeah.
I know, by the way, oftentimes you're really dealing with the insurance company, not the actual person on the other.
Yes.
Behind the other wheel. They made a mistake. They were careless. They aren't evil, bad people. They're humans.
Yeah. Yeah.
So.
Well, and part of our job is to keep people kind of in line and on track, right? So we'll have people come in and say, well, but for the grace of God, I could have been killed. Okay. There's no value in that. I understand. And let's thank God that you weren't, but there's no value in the sort of feel sorry for me claims. Let's move beyond that. We don't nurture that. We're not interested in that sort of line of thinking.
Mm-hmm. Well, going forward in these podcasts, I know you want to address current events and news items like this. Anything on tap that you think we might pick up next time? We could give listeners a little preview.
I think where we're headed with this is Julie and I, being female business owners and sort of understanding what it is to align ourselves with other really, really strong women, or values that we can align ourselves with. I think we're going to, want to start having guests and other women whose goal it is just to empower and to provide,
shine a light on other women. I mean, I mentioned this, I think men are from Mars, women are from Venus. We don't all do things the same way. And obviously, broadly speaking, men and women have a lot in common, but there's a lot of differences. And so we want to shine a spotlight on, the dynamic women out there that are doing cool things.
Yeah. And then we'll still have some fun with funny STD cases and such as it pops up. But yeah, I think we're gonna watch this sort of morph and become something just really positive and fantastic. And yeah, we're excited.
And how can listeners reach you?
Well, we're online. Law Powered by Women. We're in the phone book. Oh, wait, there's no such
Do
thing.
they make those anymore? Actually, the
No.
last time I got a phone book, I think it was like a 1/2 inch thick. I mean, nobody's in there anymore.
Go directly to my recycle bin.
Yeah. Yeah.
No, what? Google Law Powered by Women. Google Luhrsen Goldberg. Look for us on Facebook, Instagram.
Well, thank you very much for the time. I can't wait for the next episode. That's What She Pled. Follow the podcast. Make sure you know when a new episode is ready. Share with others, rate and review. Thanks so much.
Thank you for listening to That's What She Pled podcast. Don't forget to click the follow button to be notified when new episodes become available. The information covered and posted represents the views and opinions of the guest and do not necessarily represent the views or opinions of Luhrsen Goldberg lawyers. The content has been made available for general informational and educational purposes only and may not constitute the most up-to-date legal or other information. The content is not intended to be a substitute for legal advice from your individual attorney, and the information provided does not and is not intended to constitute legal advice.